2, 1. Thank you, everyone. It's 6:27, and the Affordable Housing Committee meeting will come to order. We'll go ahead with the roll call. If everyone can please raise their WebEx hand, please. Six. All right, I see 7, Swara, Chums, Mendez, Sepulveda, Sledge, Taylor, Welch. Now I lost my count. Director Cooper, can you help me with that, please? More hands came up. All right, I'll just call the roll, please. Allen?
Here.
Hauser? Mendez?
Here.
Thank you. Parker? Parker is out. Sepulveda?
Here.
Sledge?
Here.
Is it Taylor?
Present.
Chums?
Present.
Ben Welch?
Present.
I have 8 present. Thank you. I'm going to read the motion, and if I can have somebody move and second it once I finish reading. Pursuant to Governor's Lee's Executive Order number 65 regarding electronic meetings, I made a motion that this committee meeting agenda constitutes essential business of the Metropolitan Council, and that meeting electronically is necessary to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak. Can I have a motion, please?
So moved.
Second?
Second.
Thank you. Any discussion? Seeing none, all right, we'll do a roll call for that motion. Allen?
Aye.
Hauser?
Aye.
Mendes?
Aye.
Sepulveda?
Aye.
Sledge?
Aye.
Swara is aye. Taylor?
Aye.
Chums?
Aye.
And Welch? All right, thank you.
Aye.
Thank you. We have 2 items on our agenda. The first is Resolution RS 2020-614 by Van Rees, authorizes the Metro Development and Housing Agency to negotiate and enter into a pilot agreement and accept payments in lieu of the ad valorem taxes with respect to a multifamily housing project located at 600 Creative Way, known as the Briarville. Can I have a motion, please?
Second.
Thank you. Councilmember Van Rees.
Good evening. Thank you, everybody, for hanging in there tonight. I am enthusiastic about this project. It brings affordable housing right next door to Nosy College of Art and completes a vision that the community had for mixed income opportunities right at the South Central Gateway into Madison. For example, I believe it's $49,000 a year. A family of 4 will be able to provide housing there. And I'm really excited about that. Across the street, there are $400,000 townhomes being purchased. So it quite appropriately protects this part of Madison from gentrification. And I'm very excited about it, and it has full community support.
Thank you. Any further discussion? I'm looking in the queue. Councilmember Taylor. Councilmember Taylor, you have your hand raised.
Sorry, Chair, that was from earlier. Thank you.
Oh, okay. All right. If there's no further discussion, before I take the vote, I do want to say that I've invited Mr. Wilshire and MDHA to come to our December meeting. I think some of the questions that I had over the years is how do we determine the percentage of abatement? I've seen that amount fluctuates with different projects. And so he will be coming to talk to us on the process that they use, how they come up with the amount and to make sure that equity is a part of it and location and all of that. So we'll be doing that December. And with that, I'm going to take the roll call vote on this one. Allen,
Aye.
Hauser, Mendes,
Aye.
Parker, not here. Sepulveda,
Aye.
Sledge,
Aye.
Suarez, aye. Taylor,
Aye.
Toombs,
Aye.
okay. Welch.
Aye.
So I have 8-4. Anyone against? Okay, 0 against. No abstention. All right. Mr. Cooper, is that what you have? I have 8-4-0 against.
Ms. Zeitlin has actually taken the count
Oh,
on this.
thank you. Thank you, Ms. Zeitlin. Is that what you have?
Yes, I have 8 in favor, 0 against.
Thank you. Thank you. The next item on the agenda is bill on second reading. This is BL 2020-456, Highland Toombs, Bradford, and Taylor. Amends the Metro Code to require landlords to provide notice to tenants prior to termination of tenancy and non-renewal of a lease. And we have about 3 amendments. Can I have a motion to get before the committee?
So
Thank you.
moved. Second.
Thank you. Councilmember Allen.
Thank you, Madam Chair. Because we didn't have the opportunity to meet last week, I put in every amendment that I thought I might possibly want to add, but I don't necessarily want to add all of these. And also have had a substitute suggested that I would like to at least bring up for discussion. So I think what I want to start with is what I'm calling Amendment 1. That simply changed the length of notice from 90 days to 60 days. I've had some feedback from the industry folks, and they are supportive of this bill with a 60-day notification. And I believe that that is still enough time to give someone who is finding out that their lease is not going to be renewed time to find a new place to live. So with that, I would like to move Amendment 1, and then we can talk about other ways to proceed.
Second.
And that will be amendment number 3 in your packet, which is on page 13.
Okay, thank you. We'll call it Amendment 3 then.
Well, I mean, I don't know if we can call it 1, Ms. Zeitlin, but I mean, in the packet, it has 3. So I don't know if we change it to 1, but this is amendment 3 in the packet.
Yeah, that's,
Yeah, I think just call it Amendment 3 just for.
Okay.
I don't want to muddy the waters.
All right. Do you want to move out amendment 3? Oh, I think you did. Any discussion on amendment 3? I'm looking. I think everybody's tired. They want to go home. No, nobody has their hands raised. All right, we're ready to vote on amendment number 3. Roll call. Allen.
Aye.
Hauser.
Aye.
Mendes.
Aye.
Sepulveda.
Aye.
Sledge.
Aye.
Suarez, aye. Taylor.
Aye.
Toombs.
Aye.
Welch.
Aye.
So I have 9-4. Is there any opposition? Anyone here abstaining? No? All right. So amendment number 3 passes 9-4-0 against, 0 abstention. Do you want to move the other amendments, or that's the only one you want to move tonight?
That is the only one I want to move tonight. I would like a brief discussion, since it has gotten late, about a possible substitute presented as a possible way to perhaps blend together Councilmember Taylor's bill and mine, since we're essentially trying to solve the same problem, which is people discovering that they have to move out on short notice, either because the rent is the lease has been not renewed or ended before it was expected, or because that happened because of the sale of the property. So I have had some folks in the industry say they would be more comfortable with having The buyer issued the notice upon the sale of a building and that they would be supportive. And I'm not sure how to do this since I'm now talking about someone else's bill, but it was proposed as a substitute for my bill to put the two together. So I'm just going to throw it out there.
Right. So do you want to amend your bill? We move the bill as amended and then defer it so we can get to the substitute, or what do you want to do?
That is probably the best way to do it. Yes. So what I'm going to do, I'm only adding this one amendment at this point because I think that makes my bill do what I want it to do, which is to protect people when the lease ends early. But I want to make this group aware that another option has been thrown out there that would specifically deal with sale of property that would be added as part of this as a substitute, with the notification being made by the buyer as opposed to the seller. But I'm not prepared to move that at this point, but I want folks to be aware that it's out there. So that being said, I think my long-term plan would be to, now that I have amended this bill, to go ahead and defer it on second so that it will still be amendable and keep it on second reading. Eileen, can you tell me if I've done that right?
Yes, if you move to amend, or if you move to defer now, then it'll stay on second reading and it'll be amendable. This bill is only amendable on second reading.
Gotcha. Okay. All right. Then I think that's my plan. That would give me time to come back with a substitute in a timely fashion if there's a need for it. And if there's not, then I think I've got it in shape so that it could move forward as needed. That's my plan, and I would love to hear if anybody else has other thoughts.
I have a procedural question, but before I do, Councilmember Hauser?
Yes. From a logical point of view, it makes sense to have these two bills together into one. But my concern is that we might have people that be in favor of one but not the other, and we sink them both if we put them together. So I'd like feedback on that. I don't want to sink everything because people are only in support of one or the other.
Thank you. Councilmember Mendes.
Thanks. So what Councilmember Allen is referring to is that toward the middle of last week, a few people asked me to see if I could come up with something that would bridge the gap here. And through Council Director Cooper, I've proposed some substitute language, and I think Mr. Cooper has shared it with Councilmember Allen and Councilmember Taylor. And like Councilmember Allen suggested, it would marry up the two pending bills, and it would shift the notice to the buyer of the property as opposed to the seller having to guess what the intention of the buyer is going to be. And to me, you know, this is a bit of a moving target, and you know, it's on the one hand, we're doing this publicly, so that's good. We have not deliberated in advance of this, but that means it's a little bit messy. And really, what I think Councilmember Allen should be doing is, if Councilmember Taylor is not interested in a buyer-only notice, then if he's sure about that, then I think Councilmember Allen should just go forward. If he's still thinking about it and or open to the idea of a buyer-only notice, then I think deferring it one meeting. So again, if Councilmember Taylor knows for sure that the proposed substitute that we started batting around through Mr. Cooper is viable, or he's still thinking about it, I think deferral of Allen's bill makes sense. If he's sure, on the other hand, that a buyer-only notice isn't going to work for him, then I think he can tell us, and Councilmember Allen should just go forward. So I hope that helps and doesn't overly confuse things, Chair.
Thank you. Councilmember Taylor.
Thank you, Chair. So I've had a chance to read over the substitute, and one of the areas that I'm not sure about this substitute is that it doesn't allow for a intent to sell for the seller notice, and one of the main intents of my legislation was to have a notice to the seller. I mean, from the seller, the current owner of the property to the tenant. Now, Councilmember Allen's bill, I think, answers a lot of questions that did come up in regards to the conversation that we had during the BL 2022-24 conversations, and that was executing or terminating a rent too early. And so that was a lot of the conversation, but not necessarily the intent that I was looking for. I do want to look through this substitute a bit more in regards to BL 2022-24. And guys, I may have a different thought come Thursday, but as of now, I'm thinking to see if there's any opportunity that we can add that information into the substitute bill that Councilmember Mendez has offered, and go from there. But for now, I am not interested in substituting BL 2022-24 with the current legislation that's been proposed.
I tried to see if we could have a special meeting in an off week, because I really do think that, both of these are great legislation. And I was hoping we'll have the opportunity like we had with 224, where we can have a robust discussion and really talk it out with experts and people, but we could never get a time that worked for everyone. One of the reasons why I asked for the meeting to be moved till after and not 3:30 was also for the same reason, so that we can see what we can come up with and come up with something that is better. If we want to do a special meeting, if both sponsors are open to a deferral to where we now have a special call meeting, so that we can actually look at what the substitute is and discuss further. I would leave it up to the two of you, since the rest of us have not seen a substitute, and I don't even know if it's up for conversation. And so, or even if it will be filed in time by Thursday, I don't know the logistic of all of it. But I just wanted to put that out there. Councilmember Mendez.
Thanks. It's late, so I know I'm shaking my head, which I shouldn't do. I should know better. Listen, I was asked to take a stab at something I would vote for. I'll never be okay with a notice being required by the seller in advance. I'll be a no on that, like I've said at every meeting we've had before now. And I say that with the greatest of respect for what other council members are trying to do and the sponsors trying to do. Y'all are welcome. If the body wants to have a special called meeting, that's fine. But I'm hearing Councilmember Taylor, and I totally respect this, really wants a seller-driven notice either before listing or at the time a contract is signed. And at least for me personally, there's nothing to debate there. I'm going to be a no on that, no matter what version of that it is. If it's a seller-driven notice, I'm going to be a no on it for the reasons I've talked about for a couple months at our meetings. But again, and that's cool. If he is set on a seller-driven notice, I would respectfully suggest that Councilmember Allen ought to move forward with her legislation and and because there's not going to be an ability, at least for anything that I draft, to meld them together if that's a must-have for the sponsor.
Thank you. Councilmember Welch.
Thank you, Chair. I have to be honest, I apologize for being an idiot, but I cannot understand where with these two pieces of legislation that we actually end up and what the process is. I'm completely confused by these pieces of legislation and what the end result will be. And I know, or I believe that Councilmember Taylor was probably surprised that on second reading I voted against this, but because I vote against things I don't understand, I say no because I don't understand, knowing I have another chance. But I do not know. Can anybody explain to me how each piece of legislation and the melding in this legislation, what do we end up with? Who is responsible for telling who what and how? I agree 100% with the intent of Councilmember Taylor's legislation that people who live in housing and rent deserve notice. But all of this legislation is just completely overwhelming that I cannot figure out what we're actually voting on. So if anybody could tell me how any of this works, I would really appreciate it, because I just feel like an idiot. Like I've just lost the train and I don't know where it's going. So I'm not sure who to even ask that question of, but I just really don't have a sense of how all this legislation melds together and what we end up with in the end. So if someone could explain that to me, I would really appreciate it. Thank you.
I'm going to have Member Taylor respond, but I do want you to know that Councilmember Taylor's bill is not before us. This is the one that is talking about notices before the property is sold, and the notice is supposed to be from the seller at the point of listing. Councilmember Allen's bill is the one that is in front of us, and that is talking about when an agreement is to be terminated. I believe that's what it is. And so we're trying to see, since it has to do with when somebody has to leave a building, is there a way to marry the two instead of having two pieces of legislation? That's the reason why both of them is coming into play. But I think they address two different things. But is there a way to make it together? It's about protecting somebody renting before their house is being sold, or the house they're renting is being sold. What is the best way to do that? So that's where we are. And so right now we have Councilmember Allen before us. And so the idea is, because it's similar to Councilmember Taylor, people are confused as to whether they're doing the same thing or not. And so is there a way to put them together? So I'm going to have Councilmember Taylor. Oh, he put his hand down. I was going to have him, if he has anything to add on his bill.
Thank you, Chair. No, I think you did an excellent job of explaining the two. So from my vantage point, there are two very different bills, and I don't want to take up a lot of time because we are discussing Councilmember Allen's bill that I think it maybe during the filing of it caused a little bit of confusion in regards to the bill that I was sponsoring. And I guess to answer that is that Councilmember Welsh, Councilmember Swore, I'd like to just kind of answer Councilmember Welsh's question there, is that there's a lot of conversation in regards to the seller notice came in regards to BL 2022-24, which is what we're not discussing, but a lot of questions came to the forefront in regards to early termination of rent. So if a seller sells property to a new landlord and the landlord terminates the rent early. And so that's what I think where we had a bit of difference. And my legislation has nothing to do with written. It has nothing to do with termination now. Some intent is there to protect those individuals from having that maybe happen or having an idea that it may happen. But my intent was to notify the renter, the tenant, prior to a sale.
Thank you. Councilmember Allen.
Thank you, Madam Chair. Not much to add, except, I mean, simply just to make sure we've clarified what BL 2024-56, which is the one I'm sponsoring, currently does is simply said for a 12-month lease, if it doesn't already specify that the landlord will let the tenant know some amount of time ahead of time that he intends not to renew the lease, then he has to do that by 60 days ahead of time. So it simply says if your lease doesn't deal with that already, then 60 days ahead of time, the landlord has to notify the tenant that he's not going to renew the lease if that's his intent. And that's the crux of what that bill currently does.
Councilmember Allen, if I may ask, so it is possible to sell a building but not terminate a lease because the lease can transfer to the new buyer. Is that correct?
The lease has to transfer to the new buyer, and I think this is where the lawyers can come over. I mean, there's case law and property law and everything says if you buy a property and there are leases, you have to honor those leases. So that's already out there. This just simply says if under any circumstance, whether a property is sold or not, if you don't intend to renew the lease, you need to let the tenant know 60 days ahead of time so that they can find a new place to live, because that's been the issue that we've been trying to avoid, is someone having to deal with rapid rehousing. And this bill does not deal with week-to-week and month-to-month leases because the Uniform Landlord Tenant Act has already spelled that out. I simply restate what they require, which is 10 days notice for week-to-week and 30 days notice for month-to-month.
Thank you. Councilmember Hauser.
Yes, one of the questions I have, I hope some of our legal team is on the call, is, okay, when people do not follow this, one of my concerns is we can write all kinds of bills, but if there's no teeth in them, we're blowing smoke in the air. And a lot of times that's what seems to happen. And I noticed that Councilmember Allen had a $50 penalty per unit, but with that, which seems like nothing. Is that per day, $50 per day, or is that $50 period, or what is that? Because I want to know what's the maximum we can do. Because I would like to say $50 per day per unit, not just $50, because that's nothing. Because I'm in this market and I see people pull all kinds of stuff because the slap on the hand is so much less than the money they'd make otherwise. They can care less. So I'd like to, if people break the rules that we're presenting, what is the maximum we can do as a penalty for them to make this a deterrent rather than just a whoop-de-doo, see what you can do to get around the law, because I see that in real estate all the time with tenants.
This is John Cooper. I can answer that question. Assuming that there is some metro enforcement of this legislation, which under the Metro Code, the police department is the default enforcer of all metro ordinances. If under the Metro Code, the court has the authority to assess fines on a per day basis. So it could be $50 per day, but that's really up to the General Sessions Court to determine what the fine would be. But that authority is there.
Is that something that we could write into our legislation as a guidance? Because if it just says $50 per unit, then that could be all that's given. Could we have a guidance or something that we write into our ordinances, say $50 per day? So if you're supposed to be giving a 60-day notice and you only give a 30-day notice, it is 30 times 50 that you'd be fined?
If you will give me just a minute, I'll pull up the existing code section and tell you what it says.
Thank you. I appreciate that, because I think that's one of the things that we need to do with the ordinances is see, okay, if you don't do it, if you don't obey, what is the punishment so minimal that it economically makes sense to just ignore it?
It's section 1.01.030 of the code, and it says, except where otherwise provided, every day any violation of such code or ordinance of Metro it constitutes a separate offense. So that is spelled out in the code. Now, again, it's up to the court whether to actually impose that fine, but that is the way that ordinances are to be treated.
Okay, so if I understand what you're saying, as you read it, it could be $50 per day that they don't do it.
Correct.
And when these things, and I'm going to totally show my legal ignorance here. When this goes before a judge, is that just before a judge, or is there like a prosecutor, or is there somebody that makes a suggestion that there's $40, 40 days, so it's 40 times 50, and asks for that, or is that totally upon the judge to interpret?
So this is a civil offense, so it's not a criminal prosecution. In environmental court, Metro Legal has attorneys assigned to environmental court that do serve as kind of quasi-prosecutors. So typically they would be the ones, they or the department would be the ones to ask the judge for the specific penalty.
Okay, so we could put that out there. Okay.
That's correct.
Thank you.
And if I don't know if Alex Dickerson is still on the call or not, but if anybody's from legal, if they want to jump in, they can. But that's my understanding of how it works.
Okay, thank you. That helps a lot.
Thank you. And so I'm going to go back to Councilmember Taylor. Oh, Councilmember Welch, do you have another question? Your hand is still up.
I do. I was just wondering if there is a more efficient way of just like melding this legislation together, that sellers have to apply to adhere to this XYZ. Landlords have to apply to this XYZ, instead of all these amendments and all these changes and all these things that I think, if they're confusing to me, and I kind of think of myself as being on top of shit, but maybe I'm not. Oh, excuse me. Maybe I'm not. But, I just feel like we had a more comprehensive piece of legislation that addressed both aspects of this. I would feel more comfortable with that. Because they could address the unique situations of each thing as a seller and as a landlord and whatever, but we would be accomplishing what we want, which is that people who are living in these homes are not being surprised by the fact that they have no time to get out and change their life. So I'm just wondering, is there any way that we can just like meld these together and actually have one comprehensive piece of legislation that addresses both of these issues? Because they're both extremely important. And I just feel like we're going to miss something in this piecemeal, the way we've been doing things. So that would just be my question. I don't even know who it would be to. Thank you.
Thank you. Councilmember Hauser, you still have your hand up? All right, thank you. Councilmember Welch? Yeah, okay, thank you. It just allows me to see who else I've got in there. All right, Councilmember Taylor.
Thank you, Chair. I think when asking this earlier to and I do understand everyone has not had the chance to see the substitute. Mr. Cooper, could I ask that you send that now, if you could send that substitute to the entire Affordable Housing Committee, if the sponsor would like to, if Councilmember Mendez would like to. I'm not sure if he is ready for that, but I think that if we all could see the legislation at some point, we can have discussion in more detail. And again, and I will say this, I've looked at the substitute and I received it today. And thanks, Councilmember Mendez, for doing so, because we are trying to kind of mesh these two pieces of legislation together. And so of course, I've shared with you all tonight my intent with BL 2022-24, and over the last several months, I've shared that, and I think this does meet some of the requirements of the intent that I do have. And so to be quite honest, I haven't had a chance to truly make a final decision with the legislation. Again, receiving it today and kind of reading it, to be quite honest, on my phone, and haven't had a chance to get to a computer to do so until now. We all have very busy days, so I'm sure you understand. And so I, I think we can look at it, but I think Councilmember Mendez made it clear that, with this will be his substitute. I mean, and we would have to add legislation to, we'd have to add an amendment to add seller information in it. And I think he was pretty clear that that is not something that he would like to do with his legislation. So I'm going to read over it some more with clear mind over the next 24 hours, and I'll have a better understanding. Thank you, Chair.
Thank you. Councilmember Mendez.
Thanks, Chair. So what I would suggest is, so I didn't, I honestly, what I drafted was an attempt to see if there was common ground, but I didn't intend to be a sponsor. I was, if the two other sponsors, Alan and Taylor, were on the same page with what I put out there through Director Cooper, then one of them could sponsor it. And I really don't think that it's ready for prime time. If it's going to be agreed upon between Councilman Allen and Councilmember Taylor, then they can work that out through Mr. Cooper, and it can be distributed at that point. And frankly, I think that would probably work. But before, I don't intend on proposing it over the objection of one of the two other sponsors and adding yet another scenario here. And I sort of regret that we got into this conversation today, because people don't have the benefit of the attempt to bridge the gap in front of them. So maybe Councilmember Allen had it right in the front end, probably did, of just defer her bill one meeting, and then there's time for the two council members to see whether there's agreement on language or not.
Okay, I think, all right, Councilmember Allen. So I'm going to bring, that's what you wanted to do initially. So Ms. Zeitlin, this. We've already moved the amendment. So procedurally, I don't need to move the bill as amended, or do I need to move the bill as amended before we defer it?
You can, or someone can move to defer the bill as amended. You don't have to
Okay.
move the bill.
Yeah, I'll move to defer the bill as amended.
Okay.
Second.
All right. All right. Any
Second.
discussion? All right. Seeing none. All right. We're gonna go to the vote. To defer how long? Is it one meeting?
One meeting.
1 minute. All right. So the motion is to defer the bill as amended for one meeting. Allen,
Aye.
Hauser. I see Hauser. Mendez,
Aye.
Sepulveda,
Aye.
Excuse me.
yes, ma'am.
Yeah, are we talking about the bill with the one amendment or the three amendments that were being proposed? Because we've only discussed one.
Yes, she's only moving one.
Which is
Okay.
amendment 3.
Just
Not
the
the
one.
other two. Okay, thank you.
And how did you vote?
I can vote okay if we're just moving it with the one amendment that was presented. Thank you.
Sorais, hi, Taylor.
Chair, this is Sledge. I vote aye.
Taylor.
Taylor votes aye.
Toombs.
Aye.
Welch.
Aye.
All right. So I have 9 in favor, 0 against, 1 meeting deferral. All righty. I will talk to Ms. Zeitlin, and then maybe she can help us walk through if you want to do a special meeting, that is after the two sponsors have looked at it. If this is something that Councilmember Taylor wants to consider, that both of them wants to consider, then I think we should do a special meeting and just talk it out and iron it out, and then hopefully come to a better place. Then if we cannot come to an agreement, then each bill will be moving on its own. But once I get an inkling from exactly that they want to do that, then if you will please respond. We tried to do it this last week. We couldn't get one. If we can try to meet next week in an off week, try and propose a day or two that works for everybody. And then if we can try to do that. These are great bills. We're working for our constituents, and we want to do the best that we can. And I appreciate both sponsors and Councilmember Mendes for stepping in, and everybody. And so with that, I think that's all we have on our docket. And so can I have a motion to adjourn?
So moved.
All right. Thank you, guys.
Thank you. Good work.
All right. Have a good night.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.